All right. Welcome everybody to this month's industry update. Thank you so much for joining us. We're glad to have you here. I want to let everybody know about our upcoming updates. Give me 1 second here. So save the dates. September 2nd, we're going to have Merck Patinas on. He is a real estate litigator, and he's going to be talking about all those nasty situations when buyers and sellers are suing each other. It's going to be a really interesting one, so don't want to miss that. October 7th, Damian Cox is going to be talking about form changes for 2022. Hard to believe that next year is going to be upon us before we realize it. So join us for a great update on that. And
hopefully I'll have them done by then. Jeez.
Hopefully he gets them all wrapped up by then. Yep. And then November 4th, we're going to have Paul Bondi back on. He was on last December, and he's an E&O broker for real estate brokers. That's what he does. So we're going to be talking all about E&O coverages and possible gaps in protection. So he was a really well-received speaker. So please join us for that one as well. And then with that, I'd like to introduce our special guest today, Mr. Terry Williams. He is the Senior Vice President and Head of Underwriting for Heritage Title Company. He's a Colorado native, born and raised in Greeley. He started in the title business in 1976, and he's pretty much done it all ever since then, residential, commercial, you name it. He's been a manager, literally done everything in title that there is to do in title. So an incredible background. He joined Heritage in December of 1991, which means he's approaching his 30th year with Heritage. And his first project at our company was doing the title work for Coors Field, which is a really fun project for him. And future projects included the new Elitch Gardens, the Denver Aquarium, and the sale of Larimer Square. So he's got a really incredible background and resume with title projects he's worked on. He's the state underwriter for Heritage Title, and he says his basic job duties are to solve problems and get deals closed. And he does that. We've probably closed half a dozen deals since I started here a year ago that were getting hung up at other title companies. And I got it in front of Terry, and he figured out a solution. So he's an amazing resource. And he's a self-proclaimed title geek who loves the history behind every piece of property, and especially the history of Colorado in general. He thinks it's fascinating that a document recorded over 100 years ago can still impact a piece of property today. So Terry, thank you so much for joining us today. I will stop my share and we'll let you take it away. You've got some great things to talk about today.
Great. Yeah, great. Well, welcome everybody. And thanks, Jill and Damian. It's always, I've been on the, I've watched a lot of these. This is the first time I've presented one. So I've been excited about it because I always think they're always very helpful. And one of the things, so I want to talk a little bit, just some things that are trending now from an underwriting side and the closing side are power of attorneys. And I've talked to Damian and Jill about it, that there's probably not a day goes by that we don't have an issue with a power of attorney. And we see them in every type of transaction, and oftentimes it's last minute. So I want to talk a little bit about the whole issue of power of attorneys. And for us from a title company standpoint, when we see a power of attorney, we always stop, and our first thought is, why are they using a power of attorney? Is somebody incapacitated? Is somebody traveling? Is somebody overseas? In Colorado Springs, I live in Monument, and we have a lot of military, and so we get a lot of military power of attorney. So we always want to ask, why is there a power of attorney? Is it just a matter of inconvenience or that? So that's probably the first question we want to ask. And I want to share my screen real quick. Okay, you see the power of attorney?
Yep.
So we have our own forms, and we have 3 different forms, and this is a heritage form.
Hey Terry, it just went away.
Oh, what did I do?
I'm not sure.
Oh, I know what I did. I moved it.
There it is.
How's that?
Perfect.
Okay. So this is a seller power of attorney. We have 3 specific power of attorneys. We have a power of attorney for sales, for a seller, a power of attorney for a buyer, and a power of attorney for a refinance. And what I wanted to start with is this is that I, Terry Williams, County of State of Reposing Special Trust and Confidence, have made, constitute, and appointed hereby these presents do make, constitute, and appoint to be my true and lawful agent pursuant to Colorado Revised Statutes 1514-702 to act for me and in my stead and to sell and convey the following property. And I wanted to point that out because there are Colorado statutes. There is a statute that governs power of attorneys, and most title companies, their power of attorneys are going to comply with this. And actually, they really have to. In Colorado, technically, for a power of attorney to be valid, it has to comply with the statute. And that's why it's recited there. And I think most power of attorneys that title companies use recite the statute. So this is very specific: to act for me and in my stead, and to sell and convey the following property. Let's see Exhibit A, and we'll attach the legal description of the property, known as the address, or any interest in said land for such price as to my agent may seem advisable. My agent is hereby authorized to sign, seal, and deliver as my act and deed and any contract, deed, or other instrument in execution of any agreement for sale. And I'm not going to read the whole thing, but it's very specific. And talks about absolutely conveyed, assigned to the purchaser. This also allows them to sign a contract, a listing agreement, or anything else. Another important part is my agent is hereby authorized to receive the consideration or purchase price arising from the sale of such land or any interest therein, and to give good receipt thereof. And actually, there was an asterisk right here. If said consideration should be paid by check or draft, my said agent is hereby authorized to endorse and cash said check of the draft and collect the proceeds thereof. That's also very important when we're giving out sellers proceeds. It's important that if that authority is there, and if they don't want that authority, then they can strike that out. And this power of attorney shall continue to be effective even though I become disabled, incapacitated, or incompetent. Now, what we recommend is when you have a listing and you know somebody's going to be using a power of attorney, that you contact us and we will prepare this for you. We'll make sure we have the right legal description. And I'm going to go into some other examples of power of attorneys that we see that are really not done properly. So this is one for a seller. Now we also have one for a buyer. And again, it's very specific, refers to the statute. And this is my agent is hereby authorized to sign, seal, and deliver as my act any deed, any contract, deed, or trust, promissory note. Because at this point, the power of attorney for the buyer is going to sign the deed of trust and encumber the property. So it's important that they have the ability and the authority under the power of attorney to do just that. My agent.
Barry, do you want to cover the fact that if I recall correctly, and you know better than me, but the statute actually says that if it's going to be, it has to be specific to those powers. You can't just grant the general thing of you have power of attorney for anything you want to do.
Correct. And I've got the statute, and I'd be able to help to provide this with anybody, but presently exercisable general power with respect to property or a property interest subject to power of appointment means power exercisable at time in question to vest absolute ownership in the principal individually, the principal's estate, the principal's creditors, or the creditors of the principal's estate. This term includes a power of appointment not exercisable until the occurrence of a specified event, the satisfaction of the ascertained extent. So this is the actual statute. And it's very, as Damian said, it's very exact and very specific. It defines the principal, the property. We have so many power of attorneys that come through with just an address and not the legal description. And it really needs to have the legal description. Record. We have to record it, sign, and execute. So this is the statute, and it goes into, and I'll make these available. I think Jill will have these available, these copies that I'll have. But it is very specific. And I think the last time they did the statute, they really changed, and Damian, you can speak to this as well, the definition of agent. And I think that was the big change in this last time they did this. It also talks about durable. So let me go back to R. So this is the buy. This is the one for a buyer. Power of attorney shall continue to be effective even though I become disabled, incapacitated, or incompetent. And I'm going to speak to that because that's another big issue in power of attorneys. And then it has to be acknowledged properly. So if you have a buyer, you know they're going to be out of town, make sure you have them sign this as well. And oftentimes lenders will also want to review the power of attorney. And in most transactions, lenders will want to approve the power of attorney as well. We also have one more, which is just a power of attorney specifically for refinance. With the market, the way the market is these days and the amount of refinances we're doing, we want a specific one to refinance, hypothecate, give a deed of trust affecting the following property. So as you can see, power of attorneys are very specific and they have to be written properly. As I was getting ready for this program, I actually had these 3 issues come up this week, and I wanted to talk a little bit about it. The first one is we see this an awful lot. This is a general power of attorney. And Damian and I were talking about this a little bit ahead of time. State of Colorado statutory form, durable power of attorney. And you've probably all seen these, and a lot of people have them. And oftentimes this one is used when someone is possibly, I want to say elderly, or they're going to give this to their kids and have this done. But you can see it's does not authorize the agent to make healthcare decisions. And what it does, a designation of agent, I redacted that, but grant of general authority. I grant my agent and any successor agent general authority to act for me with respect to the following subjects. So it lists all these different subjects: real property, tangible personal property, stocks and bonds, all these options. And then down here, it says all preceding subjects. So the person that's granting the power of attorney just initials that. So that is giving them a general authority to do that, not very specific. And then grant of any specific authority, optional. And then again, this is supposed to be for specific acts, but again, it's pretty generic. And you can go down here and then sign all preceding subjects. So we see this a lot. Now, the problem with this one is this gentleman came, we had a closing. I don't think we had a closing scheduled yet, but they provide us this power of attorney. And there is a clause in here, delayed effective date. This general power of attorney shall become effective upon my incapacity and shall not be effective until then, in lieu of a judicial determination of my incapacity. Say a court determined that he was incompetent. I shall presume to be incapacitated, and this general power of attorney shall then become effective upon presentation of a notarized statement to that effect from either my regular physician or 2 other licensed physicians. Any person, organization, or entity to whom a statement is referred to can rely upon that. So they presented this power of attorney. Another thing as well, it was done in October of 2012. It's almost 20 years old.
Hey, you're going to talk about the delayed effective date. Why don't you do that? And then I want to get into that 20 years old or the 10 years old.
Okay, perfect.
But yeah, talk about this delayed effective date and how this creates all sorts of issues.
Yes. So when we saw this, we reached out to the agent and said, so according to this power of attorney, we need a notarized statement from his regular physician or 2 other licensed physicians. And what they sent us, this poor gentleman, he has dementia, was taken to a hospital last year, and he was, didn't know where he was, what he was doing. And so they had presented us a letter written a year ago by a staff psychiatrist that said, I interviewed this guy, he obviously has cognitive issues, and I believe he has dementia. And we said, we can't take that. He obviously has some issues, but his wishes in this power of attorney were very clear on presentation of a notarized statement. So we went back to him and said, in order for us to rely on this power of attorney, you're going to have to get those documents for us. And then Damian, I'll let you talk a little bit.
Yeah, well, the one I know that a lot of brokers on here, that one of the things that they hear from the title companies regularly, I'm sure that is it's 10 years old, but they say, oh, well, the estate attorney says it's fine, or whoever the attorney is says this is fine and it's still in place, so it's okay, so we can use this. But the fact that it's 10 years old, what does it take to revoke a power of attorney? So I just want brokers to understand why this time lapse is so important.
Mm-hmm.
So, you know,
what does it, what does it take to revoke a power of attorney?
I revoke.
Yeah, it's pretty.
That's, you know, that's literally it. I mean, you don't even have to give anything in writing. You don't have to do, I mean, revoking a power of attorney it can be verbal. And that's why you guys get these power of attorneys and the client says, oh, this is fine. My attorney says it's fine. And it looks like it's fine, but you can see where a title company is going to be a little hesitant about, wait a minute, this thing's like 20 years old and it's to the ex-wife, or it's to an estranged kid, or it's to, you know, they're going to be like, I don't know if I'm really willing to accept the risk on this, because it's so easy to revoke a power of attorney. That's why a lot of times you'll see them ask for a property specific power of attorney, like the ones that that Terry just went through, the ones that Heritage has created. They want one of those, and they want it signed recently, just to make sure that they know that the principal hasn't revoked that power of attorney at sometime in the last 20 years. So, I mean, that's the things that Terry gets to deal with when he's reviewing these is, gosh, we got to weigh what are the chances this thing has been revoked and we're going to have claims, and wait a minute, this delayed effective date says you're supposed to have these things and we don't have them, so we can't rely on it. And, you know, so keep in mind, just because attorneys say, oh, it's fine, doesn't necessarily mean the title company is going to be willing to take that risk. So, and Terry, I'm sorry, I don't mean to jump all over you.
No,
but
that's a great point, and I appreciate that, Damian. You know, another issue with this one, the letter, it was a 2-page letter that the psychiatrist for the hospital had written, that the gentleman that had done this power of attorney had said, well, everybody just wants me to die because they're going to get $1 million, and I don't want to die, and I don't want them to have my money. And there were some things in there that, boy, really gave me concern. And again, it was just so I'm not sure, this one wasn't ready to close. Actually, it was good because the agent got this to us pretty early in the transaction, but we still got a long ways to go before we can get comfortable. Because if he did intend or did revoke it at some point, and even in a verbal, you know, you think about what Damian said, if he said that verbally to a staff psychiatrist at the hospital, I'm revoking this, that could hold up in court. So that's why we're uncomfortable with these. You see a lot of them. So if you've got a listing or you've got a buyer and they have one of these, which you're going to see, especially if it's dated, I would highly recommend that we get one current. We honestly, anything over 6 months old is kind of our cutoff, and we're very uncomfortable with that. Anything, you know. Now, one thing that we do have, and because we do have some agents, we do have some people overseas, or if they're going to be gone for an extended period of time, we have what we call a power of attorney affidavit. And this is signed by that she's the attorney in fact. So being duly sworn, deposes and say that he resides at, he's the attorney in fact under a certain power of attorney executed by his principal, which power of attorneys be recorded simultaneous, that the principal is now alive and that said power of attorney has not been revoked.
Terry,
Now,
I know this seems trivial, but would you explain to everybody why it's important to have that statement that the principal is still alive?
well, it's because
I'm serious, because a lot of people don't know this.
People don't realize that. And we actually, and this is true. I had this that come up yesterday. We had an inquiry from an agent, and she said, I talked to my attorney. Mom and dad were in title, and mom and son were in title. Son passed away. Mom wants to sell the house now. And they said the 3-year statute of limitations for filing probate and to file a claim in the property has passed. So we can just sell the property now, and we have a power of attorney from mom. But which I've never even heard of anything like that. But we do have people try and use a power of attorney for somebody that is deceased.
And
I'm not.
And just to make sure we're clear, I mean, once they're deceased, power of attorney expires, guys. That's the big thing. So you could have a power of attorney for somebody getting ready to close, come up to closing. If that person dies, you can't close because the power of attorney expires with the person.
Yeah, it definitely does. So that's another one. So the general is, we do end up taking these. We do a lot of due diligence, and in order to take them. And if somebody actually is, say this gentleman, they had the actual letters currently from a doctor that stated he is incapacitated, he's in a nursing care facility, and we get a power of attorney affidavit, then we will take these. But that's an old power of attorney. And also, and even though this document, the POA affidavit, is a little self-serving, it's still.
Why don't you explain what you mean by self-serving? I mean, people need to understand why you're asking for these because of the risk. So
Good question. Yeah. So I'm the one. So if my dad, and I was actually power of attorney for my dad had dementia, and say he had passed away, and I wanted to go ahead and use this. I go ahead and say that this is me, because I'm saying that I'm signing the affidavit for my own benefit. In other words, it's self-serving, self-dealing. There isn't anybody else signing it. I'm saying to the title company, even though it could be incorrect, yeah, I'm duly sworn to poses and say that I reside here and that my dad is still alive, and I'm going to sign it. But and you may come up with this in other transactional title companies when you hear the word self-serving, self-dealing. Say somebody has a power of attorney, and say I had a power of attorney for my dad, and I deed the property to myself. Go from Terry Williams as power of attorney for Clyde Williams, and I deed the property to myself. That's a self-serving deed. I'm self-dealing. So that's that. If you hear that term, that's what that means. Now, this does put a little responsibility back onto the person that is the attorney of fact. If we ever had to go back, if there was an issue, we could rely on this somewhat. But that's the reason we ask for that. Anything else on that, Damian? You got to.
Well, I don't know if you're going to cover this or not, but what I would like to also ask is, so let's take the example I just gave. Power of attorney, let's say it's done right, wrong, doesn't really matter, but you have a power of attorney in place, and somewhere in the term of the transaction, well, actually, let's go back to the one where you said the person was incapacitated, and we have power of attorney, that one that you showed, and let's say they couldn't fix it. They can't fix it because it doesn't have any rights to make decisions on property or something along those lines. Can you tell, what happens next? What does a broker have to do when the person that is selling the property is incapacitated, and the availability of getting a power of attorney, you can't get one. You just can't get one because they're incapacitated at this point. Can you talk about, the conservatorship and that kind of thing?
Yeah, and that's a good question. So typically, if it's at that stage, and there isn't any way to get a power of attorney, then if they haven't been done already, we recommend you have to get a conservatorship, which is basically the court comes in and appoints someone to be their conservator and take care of them and deal with their property, deal with their finances. And then at that time, we really wouldn't have a power of attorney. If we were doing a sale, we would use typically a conservator's deed, where the conservator actually deeds out and conveys to the new buyer. But that takes time. The courts, the way the courts are.
That's what I was going to ask you. Can you give them a gauge as to the time? I just, brokers need to know what their options are when they get in these positions, so that they can at least advise their clients about, hey, this is what it's going to take now to get this done.
Gosh, I don't know, but I even think it would take months, I would guess.
That's my guess too. Yeah.
Minimum 30 days, I think, because you'd have to get an attorney, and you've got to provide a lot of information and documentation to the court for them to even consider putting this person in as a conservator.
Yeah, sometimes it's a registrar, but
yeah, there's a lot to do that. There's a lot to that, and
well, likewise, we talked about the power of attorneys in place. It's fine, and you get up to closing, and the principal dies.
Yes.
Why don't you, because I've seen that happen a lot. Well, not a lot. That makes it sound like all my clients only work with people that die, but I do see it quite often. Can you talk about what that looks like too? Just because there's a lot of interplay here, and a power of attorney is not the end all be all. And things that change, people need to know what happens if if you don't make it to closing in time because you had somebody that had terminal illness, was in hospice, or whatever the case may be, and you don't make it to the finish line with that transaction to close on the power of attorney, you need to know what the other option is.
Well, if we know that if they've passed away prior to the closing, then we can't take it. But we've had transactions, and it's as sad as it is, where somebody's going to come to the table that day and they pass away. I say a buyer or a seller, and they had a terminal disease, or they had some issue where they passed away. It kind of depends. If they say it was a man and a wife and they held title together as joint tenants, then she's going to be able to convey the property. If they held title, I want to talk a little bit about that later too. If they held title as tenants in common, then it's going to have to be probated. But outside of that, if you had a principal give a power of attorney to somebody and he passes away before closing, there's not much we can do, depending on the probate issue.
Yeah, and I know you're going to talk about some beneficiary deeds and some other things along this lines later, so we'll save that for later. Jill, I saw some stuff come in. Did you want to ask those questions or?
Yep. So Oki, hi Oki, was asking, how do you know if the POA was actually given? She had a specific example where there was an issue where a brother gave his sister power of attorney. She sent him away for a couple days, put his things in an apartment, and sold his townhouse without his permission.
So they had forged the power of attorney. It was forged.
Only you, Oki. Only you.
Right. So did he actually sign the power of attorney? I mean, really, I think probably to answer that first question, how do you know POA was given? You know, power of attorneys are notarized. And if that's that individual's signature, they're signing that authority. That's really the legal push forward, right? To convey that authority
they got
to somebody.
They got a parent authority. I think the buyer can rely on that when they close, and the claims are going to be between brother and sister about what authority they actually had, or what the desire of the principal was, and whether or not they breached those duties.
Yeah, and Jill's correct. You know, we rely a lot on it being acknowledged properly. We prefer, if you're using one of our power of attorneys, that we acknowledge it for you. You know, then we know that the principal didn't intend to give it. And for us, that's an ideal situation. Our power of attorney form, and we notarize it. That's a golden situation for us.
Another question here is, if a person has been declared incompetent, can a power of attorney be used?
Well, yeah, so for example, if this one gives the right, this power of attorney doesn't go into effect until they are incapacitated. So a lot of power, it depends on whether it goes into effect immediately. Some power of attorneys will go into effect immediately. Some go into effect when someone is incapacitated. For in this case, when he is deemed incapacitated, then the power of attorney goes into effect. So if somebody
the short answer is that that the power of attorney spells that out.
But the other thing I want to make sure we're clear on is that the power of attorney, though, had to be executed before they were incapacitated.
Yes.
If they become incapacitated, you cannot have an incapacitated person sign a power of attorney. There's no way to get a power of attorney once they're incapacitated. That's a conservatorship. Yes. So, you know, a lot of it depends on when was the power of attorney signed and what does it say and when does it go into effect.
Yeah. And actually notaries, you know, if somebody goes into a nursing home to have a power of attorney signed, the notary is part of their job is to determine whether that person is capable and competent and know what they're signing. And so we rely heavily on that.
All right, we've got a few more questions, Terry.
Okay, good, Jill.
Okay, so this is a quick one. Can a conservator be established ahead of probate?
So conservator and probate are two different things. Conservator, they're alive. Probate, they're dead. So that you would never, I can't think, I mean, you would never have a probate and conservatorship going on at the same time, because conservatorship ends when somebody passes away. A probate begins when somebody passes away.
Correct.
So
right.
Okay, since you're addressing POAs and or trust language, will you please touch on any glaring and or recurring issues related to trusts? In other words, will heritage title accept a certification of trust, or must the entire trust be reviewed?
Well, trust, we could do another whole class on trusts. Yeah, trusts are very common now, obviously, these days. Typically, when a seller is in a trust, you know, and the contract comes in or title's held with the seller in a trust, we rely on a statement of authority. It's a Colorado statute. We always go back to the statutes, and the statement of authority is prima facie evidence that whoever's signing that has the authority to sign on behalf of the trust or an LLC. You know, honestly, we really don't typically like to look at trust agreements because we want to we're not trust experts. we don't really want to rely on that. We rely on the statement of authority. So if it's clear cut now, what happens oftentimes if the trustee is passed away or is deceased, lots of times that brings up, you're going to have co-trustees or successor trustees. And at that point, we need to know who under the trust agreement as a successor trustee has the authority to sign the statement of authority. So we will review trusts. Again, it's, we prefer, hopefully they're just clean and the trust was done properly and they took title properly and we can rely on a statement of authority. But trusts are an issue. We spend a lot of time on those as well.
Here's a question from Lynn. Given all of COVID delays, do you have any general info on probate delays in Boulder County for enabling a property to be sold after a very recent seller death? Original POA and will beneficiary lives out of state.
A year ago, the courts were so bad, but I haven't really seen the backlog as much recently. I've seen some things where we've got some other court actions that have gotten through the courts pretty fast, but still probate's going to take a while, regardless of where the court system is. If you're going to probate somebody's estate, it's a process.
To finish off a probate does take some time because you have that creditor's notification of creditors time period and everything else. I do know that Denver and some of the other counties have a registrar, which is not actually going to the court. It's somebody that's appointed through the court to handle things like probate and conservatorships. And so in some instances, though, that process can be expedited. I did one several years ago where we had a probate and the closing was in a week, and my boss at the time sent me down to the registrar's office to sit in there for 4 hours waiting for them to have a minute that they could talk to me to try and get something signed. So if you find yourself in a position where you have to expedite something, talk to the lawyer. Sometimes there's a process for that. Sometimes there isn't, but it all depends on the different jurisdiction that you're in.
Yeah. And actually, Damian and I had talked about this earlier on. Probate's actually pretty easy in Colorado. If it's clean and you've got everything, it's actually pretty easy to do, pretty efficient, pretty quick to do.
Yeah. That being said, though, a lot of times the problem you're going to run into with real estate is going to be at the end of it's easy to notify creditors and do all this other stuff. But at the end of the real estate, when you're getting ready to sell it, there's going to be the need for a PR deed. And a lot of times you may need an attorney to sign that. Some title companies require somebody sign an affidavit saying that there's nothing owed or there's no taxes due on the estate to make sure there's no liens that come up and things. So I don't know, Terry, it's easy, but I still think the attorney would be preferential in those instances.
Absolutely. In fact, I have a note down here. Anytime you're involved in a probate, please really get a good attorney. With the advantage of the internet, people do so many things themselves because you can get any form on the internet, whether you're doing a deed, mechanics lien, it's just, and oftentimes it's wrong. It's not filled out properly. And it creates a lot of issues.
My favorite is the forms that they use across the entire nation. And it's like, well, that's nice, but in Colorado, that's not the law. So
it doesn't work. It doesn't work. I had a couple other power of attorney samples that happened this week. I just wanted to touch on briefly. I got an email from a closer yesterday. Urgent, seller just walked into closing with power of attorney. So nobody knew about it. It was on a $700,000 sale. So they sent it to us, and it was a military power of attorney. And I want to talk a little bit about military power of attorneys. And that's what this was. This guy was stationed in Fort Carson down south here, and had hand filled out this military power of attorney. And the power of attorney worked, but the problem was when he filled it out for him and he was giving it to his wife, they did not use their middle initials. And if you take title with your middle initials or middle name, the power of attorney has to reflect that. It has to reflect exactly how you took title. So I was looking at that and I thought, well, this is strange. He just signed his power of attorney yesterday. So this is Wednesday. I said, he just signed a power of attorney Tuesday. He's not overseas. Can we get another one? Well, come to find out, he was going downrange for a couple of days and just quickly had this done. And when they got to the closing, the selling agent didn't even know they were going to use a power of attorney. She just walked in with this, oh, we got this power of attorney. So it was just a seller side signing. So that's good. So he's going to come in next week and actually sign, but it's a horrible thing for a closer to be sitting there and all the documents are prepared and somebody walk in and hand a power of attorney. And then I had another example this week, which was interesting. I hadn't seen before. It's on a sale and they presented us a power of attorney. It was a year old and it was from a transaction they had done when they bought the house at another title company a year ago. And actually, Damian, I hadn't seen this language before. It actually kind of liked it. It said in the power of attorney, this power of attorney shall only be valid and expire shall only be valid for this transaction, order number so-and-so, like title company, and shall expire at the end of this transaction. And so we can't use it because it says it expired a year ago at the end of your transaction. But I hadn't seen that before. So that was actually pretty interesting that they had that language in there.
Yeah,
Terry, there was another interesting question that came in, or unless you wanted to add to that first, Damian.
No, I have nothing to add. I like what Terry said. Let's move on.
Okay.
I think the two questions you have are good, we can cover those.
Yeah.
Yeah, this is an interesting one. So this person has a listing coming up with a seller and their child on title. The adult child is intellectually disabled. The parent has a POA that is several years old. Do they need to get this updated before listing? I asked a title rep and they indicated that I should wait until we're under contract and then underwriting will review to see if it's necessary.
Well, I'm just gonna, from what Damian's expression, yeah, no, that's not what they should do. They should really, if they're really contemplating getting that done, Jill, they should get that to us as early as they can. Even before the listing, even if they're not gonna list it till the end of the year, at least let us look at it and say, oh yeah, this is what we're gonna need. And it's hard to answer a question like that without actually looking at the power of attorney or knowing the specifics. Was he a minor when he was incapacitated? Is he still a minor? You wouldn't be, well, people put minors in title, which is a whole nother issue. And,
yes, it is.
so, I'd be happy to take a look at that. That's kind of what I do. We look at that ahead of time and say, well, in order for us to ensure this, we would really need you to do this. But I would not wait till that, because who's going to sign the listing agreement? I mean, if they wait till they list it, does she have the authority to sign for him on the listing agreement and those things? So,
well, and I'll go a little further on this is that, the problem, so like the listing agreements, you're right. I mean, who's going to sign or whatever, you could say, well, the parent has authority to sign for her. So she could obviously engage somebody, even if the child hasn't yet technically, which to me is not the end of the world. But having the power of attorney reviewed as early as possible is so paramount, because what happens if it turns out that you have to go get a conservatorship? What happens if the courts are backed up? The last thing you want to be is under contract up against a whole bunch of deadlines of closing and then find out, oh my gosh, guys, we're gonna have to extend this. And the buyer doesn't want to give you an extension. Now all of a sudden your seller's in default because they can't close on the transaction. I mean, these are the things that you want to get early done.
yeah. Okay.
Okay, and go ahead, Terry.
I was going to move on, but if there's more questions about power of attorney.
There was just one quick follow-up regarding that statement of authority and trust. So a statement of authority can be drawn based upon Heritage Title's review of only the certification of trust, correct? Versus reviewing the entire trust document.
Well, not really. It's a certification of trust in Colorado, and I see those from other states where there'll be a certification of trust. We really won't look at it as long as if they took title as a trust, and as long as everybody's alive, we will just have them sign a statement of authority at closing or prepare that ahead of time for the seller to use, if that helps. We really don't. The certification of trust, I think, is more of I don't think those are real common in Colorado. The thing is, we see trusts from California, we see them from all over the country, and they're all different, and they all do them a little different. So
okay, great. Thank you.
We have to look at it, honestly. I mean, again, we're happy to look at anything ahead of time.
Perfect.
Okay, so the next, I got to open this up. The next thing I wanted to talk about, we see this a lot of beneficiary deeds. And let me get to open.
Ah, yes, the beneficiary deed.
Beneficiaries deeds. And this one is recorded, so it's not any private part. So the beneficiary deed came into play, I don't know how many years ago. It's been quite a few now.
Yeah.
as a way to get around probate and to avoid a formal probate like we've talked about, like Damian was talking about.
Yeah.
And
Yeah, before this came around, if you owned real property, you had to do probate. That's why the beneficiary deed was created, because even if it was the only asset you owned was a house, you had to do probate if there was real estate involved. That was just the way our statutes and our law worked. So that was the creation of the beneficiary deed.
Mhm. And actually, this is a really good deed. This is, and again, we have people come, we'll have people call us, say, do you have a beneficiary deed form I can fill out? Say, no, we don't have that. I highly recommend you go to an attorney. You see a good estate attorney, because you do something wrong on a beneficiary's deed or anything that has to do with probate. Once somebody's deceased, it takes a lot to unwind it. So we always recommend that, and we do not fill them out. But this is actually a good one. It recites the statute. This deed must be recorded prior to the death of the grantor in order to be effective. So in this case, K. Marie Beavers designates Deborah Goen as grantee beneficiary, whose address is Albuquerque. And so grantor transfers, sells, and conveys on grantor's death to the grantee beneficiary the following described real property, describes it. And so basically what happens upon death, and we record the death certificate, title transfers. It transfers to Deborah Goen as soon as we record that death certificate. Now, another thing about a beneficiary deed, this beneficiary deed is revocable. It does not transfer any ownership until the death of the grantor, revokes all prior beneficiaries deeds. Even if the beneficiary deed fails to convey warning execution, this beneficiary deed may disqualify the grantor from being determined eligible or from receiving Medicaid. Execution of this beneficiary deed may not avoid probate, even though I think that's the reason people do it, it may not. So this is actually a really good deed. What happens though, and this is what we're running into. So say Deborah was a granddaughter and got the house from grandma. Grandma passes away. She has a death certificate. First thing she's going to do, the family's decided they want to sell the house, is they list it. They put it on the market, and in this market, it's gone in 2 or 3 days. And we get a contract in on it. We start going through. We see there was a beneficiary deed, and our first question is, what was the date of death? And depending on that, and I've got the statute here so you can look at this. On a beneficiary's deed, you cannot do anything with the property until 4 months after the date of death. And that is a real surprise to a lot of people. So here's the actual statute. And it talks about vesting of ownership in a grantee beneficiary. So failure to record evidence or notice of interest in the property described in subsection 2 of this section within 4 months after the death of the owner shall forever bar the person from asserting an interest in the property as against all persons who do not have a notice of the interest. So what that's saying is that if there's errors out there or somebody that feels they have a claim in this property, if they don't file something or a notice that they have an interest within 4 months, they can never come back and claim an interest in that property. That's one part of this. There's another part. The interest of the grantee beneficiary shall be subject to any claim of the Department of Healthcare policy and financing for recovery of medical assistance payments. That's another issue. That's another reason we wait 4 months. And boy, that's a blow. And it's really bad news to have to tell somebody that. It comes out in our title commitment that they have to wait 4 months. And there's just, there's things sometimes title companies can ride around or insure around. This is something we can't. It's hard to do that. So it's really important. And again, this is maybe a good point, when you're taking a listing, get an O&E from Jill and see if there was a beneficiary deed or how they held title, or if they tell you that. And it's not from the date of the recording of the death certificate, it's from the actual date of death. So we have to wait 4 months before we can close the transaction. And this comes up quite a bit. So I wanted to point that out. Damian, do you have any comments?
Yeah, I'll just, sometimes people like to know why this is in there. And, the whole point, and the reason is because the point of this was to avoid probate, but it was not to avoid, the creditors of probate. Joint tenancy avoids that. And what was happening is a lot of people were deeding properties to their kids, and then things would go haywire and everything. So they tried to create a form that would help people avoid probate. But then all the creditors' attorneys said, wait a minute, if you do that, then we don't get paid, and we have rights to equity and property or whatever somebody owns if they die, including medical, which is why it has a separate one in there. So you can't just create a tool that now has an avoiding mechanism for the creditors. So that's why they give the 4 months. I mean, all in all, I mean, that's the length of time for the probate in order for you to give notice to creditors as well. So it lines up with it. But yeah, this is the reason this is in here, and this is why the title companies can't avoid this, is because if somebody has a claim to any of that money and they close on it and the money's gone because the seller's left town now, somebody's going to be stuck with that claim. So
Yeah.
and that's why
And I know of a title company that is involved in a claim right now because they did decide to close before that. And I'm familiar with the deal that grandma owned a big ranch, multi-million-dollar ranch, and had done a beneficiary deed to the grandkids. Something along the way happened. She was angry at the grandkids, so she revoked that beneficiary deed. And you have to record that revocation. She revoked that deed, did a deed to someone else. And grandma passes, and she doesn't have to tell the kids that. They don't know the deed was revoked. And grandma passes away, and this other person takes title of the property. Well, the grandkids, they filed a very large lawsuit very fast. And I don't know, I mean, the deed was done properly, but they felt that that was a perfect example that they felt they had an interest in that property, and they were going to fight in court over that. So,
and because the title company closed within that 4-month period, they get to participate. Whereas if it had happened outside of that 4 months.
And I think, though, Jill, even if they did, well, I think there was notice before. I think they noticed before the close. So I think before the title company closed, they came forward within that 4 months and said, hey, we're filing a lawsuit because we're staking a claim in this property. So I think it was done within the 4 months. But had the title company closed after the 4 months, those people are barred from ever asserting a claim. That doesn't mean they wouldn't file a claim. The title company would have to defend it. But once they figured out that grandma had died and had gone to somebody else, that's when they filed their claim. Notice on the property.
Yeah, and if it's past the 4 months, you don't have any notice, at least the title company or whoever's insuring the title can say, look, that's between you guys, go figure it out.
Exactly. Any other questions on beneficiary deed?
There were a couple questions that came up here. So first one, doesn't this serve the same purpose as conveying with a life estate interest?
Well, a life estate is a little different. If I'm going to sell my property to my kids and they want to take title, but I reserve a life estate, that means I can live there until I pass. They can't kick me out. So it's a little different because in this case, I've got a life estate. I'm going to stay alive and I'm going to live there. So beneficiary deed is the person is deceased and then title passes. So this way I pass the title, but I reserve a life estate and I get to stay there and live in there until I die. And then they have title free of the life estate. So if we see a deed where somebody reserved a life estate, we require either a copy of a death certificate, or if they're going to sell that property, that he still has a life estate, no matter who even the kids sell it to. He still has a life estate, so he can stay in there as long as he's alive. So that's the difference. The beneficiary deed it passes when it's deceased. The life estate you pass when you're alive until you're deceased.
The fun one is when they have the measuring life as somebody other than the person living in the property.
Yes.
That gets even more complicated.
Yes.
And the question here, is the property a taxable event to the beneficiary?
Well, I'm not a tax attorney. That I do not know.
From what I understand, I'm not a tax attorney either, so I'm not going to say this with authority, but I believe that when the property passes from the deceased to the beneficiary, it's similar to receiving property as through probate. So the tax implications would be similar to what somebody might have under a probate distribution. And the reason I'm saying it that way is because, there's all sorts of estate tax. There's estate tax for when people die, but it all depends on the amount of the inheritance or the amount of the estate. And, they're playing with those numbers regularly. So it all depends on the time of death and how much the estate is worth and those kind of things. But I believe that it's similar to that. But if you have somebody that has a beneficiary's deed, you do not want to be answering the question anyways. You should be sending them to their accountant to figure out what the tax consequences will be.
How we doing on time, Jill? I had one more quick thing I wanted to touch base on.
Yeah, go for it.
Okay.
We're doing great.
Okay. One thing we've ran into lately is a house is listed. We do the title work. Everybody thought it was in joint tenants, and unfortunately, it was in tenants in common. And what we have found happens over the last couple of years, people have been doing a lot of refinances. And say husband and wife are entitled, wife can't qualify for the loan, so they just deed to the husband. He does the deed of trust. Or let me give you another example. If they're in and out of a trust, but people will do quitclaim deeds back and forth, and lots of times a quitclaim deed is not in joint tenants. So even though they think they're in joint tenants, they're not. If a deed is silent as to the tenancy, it's considered tenants in common. I've had a couple of these recently where everybody thought it was joint tenants, and you look at the deed, and even if it's a warranty deed, again, if it doesn't state anything, it's tenants in common. So it's unfortunate where people think that they have been in joint tenants and it should be a simple process. It isn't, and we have to do a probate on that. So that's another reason I recommend, getting an O&E early on and looking at that deed. And especially if somebody has been deceased, have me look at that early on in the transaction or early on, so we can determine and make sure that it is just going to be joint tenants. It is going to be relatively simple and easy to do.
And that's a great point, because I see that all the time, and it's usually podunk Q title that decides they're going to do something screwy with the refinance in order to help the parties get it closed, and then they mess up the deed, and it's a big mess.
Quitclaim deeds never specify tenancy. I mean, the standard quitclaim deed is just that. We've had a couple, and I wanted to bring up, if you know that there's been a probate or somebody's deceased, let us know. And this is a true story. We were sitting at a closer at a closing, and had an agent walk in and say, "Oh, by the way, here's the seller's dead. Here's the death certificate," and bring us a death certificate to the table. And luckily, it was joint tenancy. But like in anything, whether it's a power of attorney, a trust, anything unusual, the earlier we know, the more we can help you get this thing closed. Nobody likes surprises, and especially at the end. And again, I had another note here, is that don't do it yourself. Hire a really good attorney to do it, because once a document's recorded incorrectly, you can't really unring that bell. It's pretty well done.
Yeah, the probate gets difficult if you do the deed of distribution and you mess that up. Then that can be all sorts of problems of having to reopen probate and try and redistribute, or it gets tricky.
Mm-hmm. It does.
Something else we talked about mentioning today, if it would be worthwhile to those of you in attendance, is talking about general warranty deeds versus special warranty deeds. I get that question quite a bit, and some of you may or may not know, but a few summers ago, the deed statutes for the state of Colorado changed, which means that the way those deeds perform is different than it has been historically. So I'll let either of you take that from there.
Well, I think I'll let Damian take that, since he basically wrote that.
Yeah, I was involved in it. I won't take credit. I won't even say who that should take credit, because the deed statute has been it has been a mess for decades. Mm-hmm. And Terry, I'm sure I think you've been around in title for almost as long as I've been alive, but so I'm sure that you saw a lot of this stuff, but it's always been a mess. You had the attorneys that all want special warranty deeds, the brokers that always insisted on general warranty deeds, the title companies that just didn't want to be liable for deeds. It was just this big mess of everybody kind of, and there was no alignment between the parties as far as who wanted what. So it was constant fighting over the attorney's trying to do this and the title company's like, wait a minute, we don't know if we want that. And, and brokers like, oh, but we have to have this. And so the deed statute really did something really cool. And what I'm going to say here, and I say this tongue in cheek because there's some people on here that may hold it against me, but at this point, there is such a small difference between a general warranty deed and a special warranty deed. I don't care which one you use anymore. That was the beauty of the deed statute, was that it really kind of aligned all the interests of the parties, whether it was the title companies, the lawyers, or the brokers. You can do a general warranty deed. It does give warranties all the way back to patent. However, it only gives warranties back to patent, but then it strips out any warranties for anything that's of record. So that really protects the seller so that they're now all of a sudden not warranting for things that they may not have known about, which was always the problem with the general warranty deed that the lawyers didn't like. The special warranty deed is still available. It does offer a little bit more protection for a seller than a general warranty deed, but the difference between the two is so minor if you go by the preparation of the deed statute that was put together. And what the deed statute did is it says, hey, title companies, because remember, they're the third leg in this chair. Hey, title companies, we're going to give you permission to create deeds now, because before they were always a scrivener for the broker, which created problems too. But since they've always been the custodians of the public record, they've always been the ones that, guys like Terry are out there always scouring the public record, making sure that it stays intact. That's why they have the requirements. That's why they want to make sure that you have a good transfer of title of all property. They're the ones that are the custodians of the public record. They really are. And so this deed statute essentially recognized their role as the custodians and said, okay, title companies, you guys can prepare these deeds as long as you do it by our requirements. And that way you can continue to be that custodian and make sure that it's properly transferred. So that's what it did. I mean, Terry, do you feel like, am I saying something different, or do you that I don't see general warranty deeds and special warranty deeds much different anymore?
It really isn't. And as you and I talked a little bit about before, at the end of the day, everybody's going to be relying on the title policy anyway. If anybody does come back and make a claim under the warranties, which I don't know if people really realize that can happen, that you've got that the title policy is going to be your defense if somebody makes a claim against you.
Yeah, that's a good point. I'd like to point out, everybody was also worried about the deeds and the deeds and the warranties, and what warranties are the sellers giving and what warranties are the buyers getting and all these things. And the important thing to remember is that, the deeds, these general warranty deeds, they're only as good as the seller. That's who's giving the warranties, is the seller. So if the seller dies, you don't have many warranties. If the seller moves to Nova Scotia and you can't find them, hard to enforce your warranties. If the seller is insolvent, back in the day of short sales, we used to have all these sellers giving general warranty deeds to buyers. What good were those? They didn't have any money. They were upside down in their houses. They were owed debts to the deficiency judgments. Those warranties were essentially worthless.
Mm-hmm.
And so the best thing about the deed statute, as Terry was saying, is that it's like, okay, guys, let's embrace the fact that at the end of the day, the title companies are the custodians. But the reason they're the custodians is because they're the ones that are ensuring title. They're the ones to make sure that if the buyer has a problem, the buyer has recourse in their policy. And so, for you guys out there thinking title doesn't matter, this is where it does matter, because you want to make sure that if the buyer is going to have somebody making a claim against their title, you want to make sure that your title company is solvent. You want to make sure that your title company is still going to be around. You want to make sure that the title company is going to insure over it, that they're going to handle the claims. Those are the important things. And that's really where the protection of title is now, is in these policies. So I'm sorry, Terry, go ahead.
That's a great answer. No, I appreciate that, Damian. That's exactly right. No, the deed statute made it easier for everybody, especially for us all the way around. Just the language, and we think it was great. I think it's great.
You have to say that because I'm on the call, but that's
no,
fine.
It simplified my life, which helps a lot.
Yeah, but like I said, guys, I wouldn't focus so much on the deeds. Jill says she's getting questions about the deeds. The deeds, to me, general warranty, special warranty, I don't care. If you represent the buyer, what I'd be focusing on is who's writing the policy. Are we getting a good policy? And buyer, make sure that you review that title commitment, because that baby is what's going to protect you. And you need to know what the exceptions are in that Schedule B2 exceptions.
That's a great point. Yeah. Oftentimes we'll have, sometimes in some of these new subdivisions, the amount of exceptions anymore are just crazy. But oftentimes a buyer will be confused and not understand that. I'm more than happy to sit down with the buyers and go through it. And say, this is why we showed this. Here's a copy of it, and kind of walk them through that. If they're uncomfortable about something, we can give coverage over certain things, minerals, depending on where they're at, but some of those things. So, yeah.
That's awesome. That's nice that you do that. I always tell people, start with the title company, but then tell your buyer that if they're not comfortable with what the title company's saying or what they do with their title commitment, then it's time to hire a lawyer to review everything and find out what their true risk is.
Another question I get a lot is about personal representatives deeds. Do you mind touching on that real quickly as far as coverages with a PR's deed or warranties? What does that behave like as far as other deeds, and what do those coverages look like?
Well, there really aren't any warranties under a personal representative's deed.
It's a bargain and sale deed.
Aren't.
Yeah, and it's essentially a bargain and sale deed. So there's three or four sets of deeds in Colorado if you don't count the beneficiary's deed, which I really don't, because it's a little different beast. General warranty, special warranty deed, bargain and sale, and quick claim. And Terry already alluded to the quick claim, and I will tell you, I would never, ever, ever tell anybody to ever use a quick claim deed. It causes more problems than it ever solves. It doesn't convey future interest. It's a terrible, terrible deed, in my opinion. Terry, you have any opinions on that, or?
No, I agree. 100%. I could do a quick claim deed on your house.
Yeah.
If I have any interest, I do. But for many years, people have used those, and we get a lot of questions these days under a title policy. Somebody wants to, say they're going to put it in their LLC or add somebody. Under the current title policy, if you convey it to your LLC or your trust, coverage will continue. But if you really read the policy, if you use a quick claim deed, it really doesn't, because you have to continue to use warranties. So we'll tell people now, we want some type of a warranty deed. If you're going to add a spouse, convert, change it, or you're going to deed it to your trust, you want to make sure your coverage continues under that policy.
That's actually a change to the policy too, because it used to be the Fairway endorsement said you change ownership in an LLC, we don't cover it, period. Yeah. And you lost your insurance. So that's actually a good change in coverage. But
I haven't heard that term in a long time, Damian.
Yeah, Fairway endorsement.
Fairway endorsement, yeah.
Oh, great. Now I'm getting antiquated. Okay. But as far as the personal representatives deeds, the trustees deeds, I'm trying to think of some of the others, the sheriff's deeds, all of those are bargain and sale deeds, guys. They have zero warranties, which means the buyer is not getting any warranties from the seller. What the seller is saying, if I got it, you get it. If I get it later, you get it. And that's it. That's really all they're doing. They're not warranting anything else. Again, in those instances, I'll say it's even more important that you make sure you're happy with your title policy, because you're not getting anything from the seller. That's really where you got to make sure that policy's in place and the buyer's happy with it.
And if you think about a personal representative, they're just that. They're not familiar with the property. Oftentimes we always require an affidavit signed by the seller as to mechanics, liens, lawsuits. And a lot of them, savvy ones, won't sign those because they say, I can't attest to what's going on with the HOA and the subdivision if there's any assessments coming. That's why the title policy is critical.
Yeah, and same with like a confirmation deed from the public trustee. They're not going to give any warranties. They're going to say, whatever it is, it is. There you go.
So Damian, tell us why you don't like the quick claim versus a bargain and sale. If the bargain and sale isn't offering warranties, quick claim doesn't offer warranties. Why don't you like the quick claim?
There's one big difference between a quick claim and a bargain and sale, and that's about future interests. And so what a bargain and sale deed does is it says, okay, so if I were to give a quick claim deed to Terry and I say, hey, Terry, here's my house, I quick claim it. What a quick claim deed says is if I got it, I got it. If I don't, I don't. And whatever I have at the time that I sign that deed, Terry gets. But let's say that I sign a quick claim deed to him, and then later on, it turns out I have water rights or mineral rights on my property, and there was a problem in title way up here, and somebody fixes the issue with title. And all of a sudden, these water rights flow through the chain of title, through the warranties of general warranty deeds and special warranty deeds and bargain and sale deeds. And they get to me, they get stuck because I gave a quitclaim deed, which means that Terry doesn't get those anymore, which also creates issues for the title companies, because if they see an issue with title that gets cleaned up, they have to go back through and make sure that the chain of title didn't include some quitclaim deed along the way. Otherwise, somebody's going to have to go back and open probate and have to reissue whatever those rights are in the property. So a bargain and sale deed just keeps things a lot cleaner, because it says, I'm giving you what I got, and if I get it in the future, you get it too, which makes it just much more effective. And Terry, I'm sorry, do you have anything?
No, that's, we refer to it as after acquired title.
Yeah,
which is exactly what you said. If you acquire something after, with a bargain and sale deed, that passes on, and that'll continue to convey. Or again, a quitclaim deed. I discourage the use of a quitclaim deed all the time, especially somebody really in most anything. And if you think about it too, if you're doing a quitclaim deed back and forth, and when you go to sell your house, you have to do a general warranty deed or a special warranty deed. It's hard to warrant title when you receive it with a quitclaim deed.
yeah, exactly. Good point.
We did have a few questions come into Q&A, so we'll address these. So first of all, can you please clarify, if you add someone to title via a quitclaim deed, can you specify tenancy? Example, the owner on title is an individual, then adds wife to title. Where would you specify joint tenancy?
You can definitely do that, but you need to add that. So you just need to add Damian Cox, Jill Cox as joint tenants. I would do it right there, and behind your name.
And I would say, don't use a quitclaim deed.
Yes, don't use a quitclaim deed. Yeah. Use a
There's
special
a question
warranty
before
deed.
we had that
Yes.
discussion.
Yeah,
So.
yeah, and guys, I'll tell you guys, there are real estate commission approved deeds on the commission's website. So if a client needs a deed, you can send them there. For the love of God, please do not fill out the deed forms for them, but you can send them there and tell them, if you're going to do it as joint tenants, make sure you specify it's as joint tenants. But there is that resource for you guys there as far as commission approved forms.
Okay. I'm not totally sure on this one. Where does a trust deed fit in? So when a trust is selling a property, so what
We
kind of
typically
deed would
just
you
use
use with a trust?
if a trust takes title, we will typically just prepare a warranty deed for that trust deeding out. So that Terry Williams Trust takes title, Terry Williams Trust will deed out. You do see sometimes trustees deeds. I think those are more when they're doing a distribution of the trust. Maybe an attorney will, so the trust is over and they're going to distribute out of the trust. So use a trustee's deed to distribute out. But typically it's just a general or special warranty deed is what we use.
Yeah, if the attorney requires a trustee's deed, you can bet that it's a bargain and sale deed.
Yes, that's a great point. They're very, very limited. That's a great point, Damian. Yeah, very limited. And
then
that's
last
something, again, an attorney would prepare.
Last question, beyond using heritage title, what is the method of checking the solvency of a title company?
Well, I think there's a lot of resources. I would always start with the Division of Insurance, the Colorado Division of Insurance. All title companies have to keep their records there. If you're a publicly traded company like we are, you can check the Dun & Bradstreet and all those types of resources. Outside of that, I'm not sure. We're direct. We are the underwriter for Commonwealth Title. A lot of companies in town are agents, so we are actually owned by Fidelity National Financial. We're a direct operation. We're part of we call it the F&F family, publicly traded company. I don't know, 300, 350. I can't think of the name of the list.
Fortune 500.
Fortune 500. Thank you.
Yeah.
Fortune 500. Thank you. If it's a local title company, you're going to want to look at the strength of the local title company along with the strength of their underwriter. So you've got two different entities there. You've got a locally owned title company and then their underwriter and who they underwrite for. And you always want to look to the strength of the underwriter. And you can always check with the underwriter, the strength of the underwriter, probably through Dun & Bradstreet. And there's probably some other resources out there that you can check. We all know that there were a lot of title companies that went under in 07, 08, and we still are dealing with that, unfortunately. Somebody has a title policy, they have a claim. Not only is the local company gone, the underwriter's gone. Strengthening the underwriter is really, really critical. You want to look at their reserves. The division, we have to have a certain amount of money in reserves to cover claims. We have literally billions of dollars in reserves because the title company always has to have reserves. So I think those are things you can check on. You can probably go on the title company's website and maybe get some information from that as well.
Yeah, they all let you know on their websites how financially solvent they are. They're all financially sound if you go to their websites.
Yeah.
Couple follow-ups on that, and then we'll wrap up today. So any reason not to use a lender's title company, some of these in-house affiliated title companies, for example, Rocket Mortgage has Amrock as their title company in-house.
That's a really great question. And I run into this a lot. And I don't think there's anything wrong with those title companies because oftentimes they have national underwriters, but they're sitting in New Jersey writing title insurance in Colorado. They don't know about in Jefferson County that you're going to have access issues, or out east you're going to have mineral issues, and maybe you can give coverage over that. I think one of the biggest things they don't understand is mechanics lien coverage in Colorado. That's very different from a lot of places. They don't know that we're one of the only states that has a public trustee, not a private, we're not a mortgage state. We don't have private trustees. So I don't think there's much you can do about it if Rocket Mortgage is going to use that title company. But whenever I see one of their commitments, I see a lot of things on there that I would never put on a local commitment here because they have to write a title commitment that covers everybody in the country. If you think about that, they're sitting back east and they don't really, I think they probably do. I don't know how they work. They probably have some generalizations for Colorado, but for the most part, I'll see some things in there. Somebody's doing a refi in Colorado and they're talking about tidal and coastal waters, which is what you get on the west and east coast, tides and coast waters.
We don't have those here?
We don't have those here.
Oh.
Well, maybe lately, I don't know, a lot of rain. So that's the problem. And, I always personally, I just think it's good to use local people whenever you can, because you can call me up. If you've got a problem on a Rocket Mortgage deal, there's nobody to talk to at their title company. You got one here, you can call me up and I can, again, my goal is to solve problems and get deals closed, and I can do that. But when you're talking to a call center in Dallas, it's tough to do.
I tend to see a lot of stuff on those commitments that are exceptions that I'm like, this isn't cool. And with the refinance, it's the lender's policy, so whatever. But I'll tell you, with a resale policy, I would be concerned.
I agree with that.
There was a quick last question with the deed. So if you've got only the husband on the loan and the deed, what's the best thing to do to add the wife? They've always done quit claim deeds in the past. So what kind
bargain
of
and sale deed? Same thing, bargain and sale deed. Make sure you say joint tenancy.
Exactly.
Okay, perfect. All right. Well, I think we'll conclude today. Terry and Damian, thank you so much.
Thank
Terry,
you all.
You're a legend in title and just an incredible resource. Legend does not mean old. I know everybody thinks that, but
well, it goes along with it in my case, but that's okay. That's all right. I still love doing it.
You really are an incredible resource. And please, all of you out there, if you ever do run into any challenges with title, please reach out. We love to help. We love to be a resource. Terry is amazing, as you can see, and we'll do everything we can to get you across the finish line and get you a yes answer. So thank you so much for joining us, and we'll hope to see you next month.
Okay, great. Thank you.
All right. Thank you.
Thanks, Terry.
Thanks.